State your name and your occupation.
Mark Gatika, attorney at law.
What type of law do you practice?
Primarily commercial litigation, but also family law and appellate law, and some insurance defense.
Can you explain family law?
Well, family law involves several different types of law. The biggest part of it is divorce and custody litigation. It also includes child support cases, visitation cases, some juvenile justice cases, and domestic violence matters.
How many domestic violence cases have you handled?
That's hard to say. Over the 30 years, not a lot, but maybe 10 to 15.
And of those cases, how many of the victims were between the ages of 18 and 25?
Maybe 3 or 4.
In domestic violence cases, is there a certain process taken for seeking protection?
Well, there are actually 2 processes that go on. There's the civil process and there's a criminal process. They both can take place at the same time. One involves charging the perpetrator of the domestic violence or the crime, and the other is seeking protection for the victim or victims, since sometimes it's usually in a family situation and it can be multiple victims in one case.
How do the processes work?
You start the process by going to the police department or the courthouse and initiating a complaint. With the civil process, you go to the courthouse and fill out the forms to obtain an injunction. And what that means is you are getting an order from the court telling the perpetrator to stay away from the victim and not commit any more acts of violence. In order to get the temporary injunction, you have to allege that you are in fear of imminent physical harm. The court will, if the judge will look over the affidavit that you file, and if the facts alleged are sufficient, a temporary injunction will be issued. Now, the temporary injunction is only good for usually 30 days. Then you have to go back to court to seek a permanent injunction. If you don't show up at court on the date of the hearing, the temporary injunction will be dissolved. If the other party doesn't show up, then it gets granted. Otherwise, you have to go through a hearing and you have to prove your case in front of a judge. Now, the criminal procedure is alleging the same facts and going to the police department so that they can then charge the person with a crime. And if they find compelling evidence, they can go and arrest the person.
What advice would you give the victim to ensure their safety?
Well, number one, initiate the process. The court can't help you, the police can't help you if you don't start the process. Number two is remember that the process all it produces is a piece of paper. The piece of paper is a court order which has the effect of becoming a law, but it's still just a piece of paper. You need to stay away from that person and not have any contact with them in order to make the injunction effective. It doesn't do you any good to start the process, but then just continue to have a relationship with the person. That encourages them to disobey the injunction, and it makes it harder to prove your case in the event that you have further problems down the line.
What is the thing victims fear most when beginning the legal process?
Well, a lot of them, in the worst cases, they fear having to see the other person in court, or having to see them at all, because once you start the process, remember, the initial injunction is only a temporary injunction. It's going to expire in 30 days. So you have to go back to court and prove your case. That means you have to sit across at one table while the perpetrator is sitting at another table, and you both get to tell your side of the story. So that's what can cause some fear for some of the victims. Another thing is that it will enrage the perpetrator and just make them lash out even more. and sometimes that happens.